So having the handout will be good. We are recording, but we're only recording the room. We're not recording the questions or the people online. So the people in the room who do not wish to be recorded can move that way or that way.
Oh, yeah.
Yeah, you can find a space where you're not on screen, or you can move back. But we're not recording the questions. We're just recording the panels because we knew we had a lot of people who were very interested in it. So while we're here, I'd like to acknowledge that we're on the lands of the Wurundjeri people of the Kulin Nation. I'd like to pay my respects to their elders past, present, and to any Indigenous or First Nations people here today. This site, we're on the site of the old Royal Women's Hospital, which has significance for Indigenous and First Nations people. It was a birthing site before even the hospital was there, so it resonates in that way. And in fact, we have down in the middle that you, the audience, can't see, but we can see there's an oculus which is supposed to represent and be a reminder of the birthing practices that we took place here. This is also a site of sorrow for Indigenous and First Nations people because it's a place where many babies were taken from their mothers as part of the His Stolen Generation, a practice that continued in Australia till quite recently. So it's both a site of joy and great sorrow, as is the case with human birthing. So I just, want everybody to reflect and think about that for a moment before we move forward. And now then I will have the great pleasure of introducing the speakers, and I'm going to read off my phone to do that. I'm not going to read out all their skills and expertise because it would take too long, because they're all very accomplished and I'm feeling very humble. But I'm going to begin with Maureen Turner, who will speak first. And Maureen is a highly respected leader in health informatics. And the way we know her is that she is Chief Executive Officer at BioGrid Australia, with over 15 years experience in healthcare and research. And Maureen is passionate about advancing data integration and collaborative research efforts across the country. And I'll encourage you to read more about her skills, but we're delighted to have Maureen here to share that expertise. Our second speaker is Frances Wheelahan, who is a partner at Corrs Chambers Westgarth, which has been a very good friend of Melbourne Law School and the Centre for AI and Digital Ethics, and many other people as well. They've been long-term supporters, collaborators, teachers. And Fran has a very distinguished history and CV, and Frances specialises, however, in transactions and advice related to ownership, commercialisations, dealings with intellectual property and technology, and she has tremendous expertise in the types of issues we're talking about today, compliance with the Privacy Act and the type of commercial arrangements that are put in place dealing with data, AI and innovation. So we're delighted to have Frances here today. And then our next speaker is the wonderful Professor Mark Taylor, long-term colleague, friend, also director of the Collaboration for Better Health and Regulation Initiative at Melbourne Law School and Helix Melbourne. And Mark's research is focused on the regulation of personal information with an emphasis on health information and genetic data. And Mark has expertise in privacy law, data protection, which in fact he's just come from teaching with another course partner, and are particularly interested in this idea that I think really is going to resonate with all of us about trustworthy governance of health, and particularly where we're using data for secondary health purposes. And then our final but also amazing speaker is Dr. Kit Huckvale, who I also have had the pleasure of hearing speak many times and enjoyed his expertise. Kit is the Acting Director of the Centre for Digital Transformation of Health, and also before that was the Deputy Director, is that right? So long-term history with that wonderful centre, the Centre for the Digital Transformation of Health, which is about translating ideas, I guess, into practice in the health sector. And that centre is an offshoot of the faculty, or is part of the Faculty of Medicine, Dentistry, Health Science and University, but it's housed here in Melbourne Connect and has an amazing collaboration across different disciplinary researchers and is doing a tremendous amount with AI and data and digital. So really good panel. And at this point, I can sit back. But what we're going to do is we're going to hear from each of these speakers. They're going to really take us through the journey of this particular innovation, and then we'll have a little bit of time for questions at the end. But we begin with data and technology and medical information. So over to you, Maureen.
Thanks, Junie, and welcome to everyone here. So I just might set clinical setting for the use of data for research that happens today for clinical research. Currently, under the Privacy Act, it's in, I guess, layman's terms, you might say that's more of an implied consent model, whereby if a patient is going to see their medical practitioner, then the collection of that data is utilised for the care of that patient. The doctor doesn't have to ask for that data to be collected for that purpose, and that data can be passed on to another health professional to be able to help with the care of that patient. Now, if we put that into the research setting, so long as the data is handled appropriately, de-identified appropriately, then that data can be used under a waiver of consent, which is provided for by the ethics committees to be able to enable that data to be used for research. So there are consent models already in operation around the use of clinical data for research, and a lot is done under waiver of consent, but of course there are different scenarios where consent is required, and that's particularly around rare diseases where that needs to be the case with much smaller cohorts of patients. But waiver of consent is quite common for medical research. But I think it's important to also note in this setting that in the clinical setting, currently today, if we take the Victorian setting, for example, generative AI, for example, is not approved for use for clinical use. In the research setting, AI is beginning to be used. I mean, machine learning has been used for some time in research, but the use of AI is starting to be utilised as well, and that's usually in the context of the data being sufficiently de-identified for that purpose. But it's not just about the legal setting, and my learned friends here that come from the law setting will certainly give a lot of insight into that. But it's also about the ethical considerations of the use of the data. And I think that's very important because there are also perceptions of use. And perceptions of use, it might be that it meets legal requirements, but does it meet what the public's perception is to how it should be utilised? So the reason why I say that is because there are examples that have occurred over time where data has been utilised for research, where the data has been provided to a commercial company without people knowing about it, and that tends to get the community concerned. So I think what's very important in the use of AI in research is that it's open, it's transparent, and if it's utilised in the sort of academic and not-for-profit sector for research, which is where a lot of research does occur, then I think the public is more accepting of the fact that it might be under a waiver of consent. And certainly that's been our experience to date, working with a number of partners with this kind of data. But as soon as you're going to be working with a commercial company, I think that the public's perception is a bit different around that, even if there is legal and ethical arrangements that allow that to happen. So what we're finding is that it's very important to involve consumers in your research design right from the very beginning. And in fact, even funding parties like the National Health and Medical Research Council encourage this as a part of putting your research study together. But we mean really embedded in your research design, not just as a token, but to really get them embedded in that design. And that is so helpful when it comes to things like involving AI in your clinical research. And we've certainly found that with 7 of the partners that we're working with, where they take consumer involvement very seriously. And it helps to be able to bring your research to life in an environment that the community would be more comfortable with. And a lot of it's around communication, how you word things, how you approach, how you do your design work, but it makes a huge difference in terms of the community being comfortable about conducting that research. So I think in summary, using AI in research in Australia is still really in its infancy. One issue I would like to outline is that the only approved clinical data set for AI research is one that's in the US, and there isn't an Australian data set that's actually approved for AI research, clinical research that is. And that's something that quite a number in the field here in Australia are trying to get funding for, so that they can develop clinical data sets for AI use, because we know that if the data is biased or has issues with it, then it's not going to be helpful in terms of using it for AI. I think in summary, we need to consider not just the legal, but the ethical considerations, the community awareness, and to be aware that that it is an emerging field where there is still, there is still some commentary and advisory information that's very specific to a clinical setting, some about whether it's devices or not, but it's not really very clear in some areas of research, and that's still an emerging field.
Thank you so much. So that's a lovely setting of the scene, and in terms of innovation and the importance of data in design. Over to you.
Thanks, Maureen, and thanks, Jenny. So I'll bring the legal perspective, in particular in relation to the OAIC's preliminary inquiries into IMED. So it was on the 31st of July this year that Australia's Commonwealth Privacy Regulator, the OAIC, released its report on its preliminary inquiries into the IMED radiology network. Now, these preliminary inquiries were perhaps prompted back in September 2024 by an article that was published in Crikey Media, alleging that millions, and it now seems like around 30 million, patient scans and reports held by IMED, which is the country's largest diagnostic imaging network, had been provided to Annalise.ai. And the data was provided to Annalise to train the diagnostic AI model, and there was neither notice nor consent from the relevant patients obtained to that provision. So Annalise is a healthcare AI startup, which was a former joint venture between IMED and also Harrison.ai, which is really quite a large AI company. I understand now Annalise is fully owned by Harrison.ai. The preliminary inquiries were closed in July with no further action to be taken against IMED, as the Commissioner had found that the data in question was found to be properly de-identified and therefore not subject to regulation under the Privacy Act, and that's the critical point. So I'll run through some of the key findings from the inquiries, and they do provide a useful case study to supplement the OAIC's existing guidance in relation to de-identification, which to date had been fairly high level and quite deliberately so, but this provides a bit of a dive into the particular measures that we use there, and hopefully some commentary from the Commissioner in terms of her satisfaction that that was a sufficient approach in that circumstance. And Mark will talk a little bit about, well, what wasn't dealt with and where are the question marks here, and sort of going back to that point about ethics and patient trust, etc. Of interest, the report that was published by the OAIC, and it's online, you can go and read it if you'd like to, it's quite brief. It states that the Commissioner decided to publish this report in the public interest to inform the community of the outcome of the inquiries and as a case study of good privacy practice. It's still open to the Commissioner to commence an investigation of IMED with respect to these or other practices, and this case study should not be taken to be an endorsement of IMED's acts or practices or an assurance of their broader compliance with the APPs more generally. So it came with that caveat, but there's some interesting things we can take away. So I thought I'd just talk briefly about some of the key privacy principles that are relevant to this situation and that were under consideration in the inquiries. So there are, of course, a range of obligations that are described in the Australian Privacy Principles, or APPs, that sit under the Commonwealth Privacy Act, and they apply to the handling of personal information, including in connection with its use to train an AI model. And an act or practice of an entity will be an interference with the privacy of an individual if the act or practice breaches an APP. So there are a number of different APPs that are relevant to this sort of scenario, including APP 1.2, which is somewhat like an overarching obligation, which requires an entity to take reasonable steps to implement practices, procedures and systems that will ensure compliance with the APPs. That's sort of an organisational requirement. APP 5, which requires an entity to notify an individual about a range of matters at or about the time their information is collected, including in relation to the purposes for which the entity collects that information and the other parties it discloses the information to. So if you're collecting information which you plan to de-identify to train an AI model, should you disclose that to the patients at the time of collection? And most importantly, probably for the purposes of these inquiries, was APP 6, which requires that health information, which is a type of personal information, only be used by an entity for the primary purpose for which it was collected or a directly related purpose that the individual would reasonably expect, unless there's an exception that applies. And then APP 10, which requires an entity to take such steps as are reasonable in the circumstances to ensure the quality of the PI that it collects, uses and discloses. And APP 11, which requires an entity to take such steps as are reasonable in the circumstances to protect personal information from misuse, interference, loss and unauthorised access, etc. So that's sort of around security of the information. So these are all really relevant. However, the APPs will only apply to personal information, being information about an identified or reasonably identifiable individual. And if personal information is properly de-identified, then it won't be subject to those APPs and the Privacy Act. And the OAIC, the Privacy Commissioner's Office, has published guidance that states that information will be de-identified where the risk of an individual being re-identified in the data is very low in the relevant release context. So you need to think about the context of release. Even though it may be technically possible to identify an individual from information, if doing so is so impractical that there is almost no likelihood of it occurring, the information will not generally be regarded as personal information. Relevant factors you might consider in that context is the cost and the difficulty and the practicality and the likelihood of re-identification. So that's not to say, though, that de-identified data shouldn't still be handled very carefully. There could be circumstances where it's de-identified in one person's hands, but not in the other. So you still need to be very careful who you might pass the identified data on to, or if there is a data breach and the information gets into the public domain, then it's open to the world at large, essentially, to potentially re-identify that information. So back to the preliminary inquiries. After reviewing IMED's data practices, the Commissioner was satisfied that the measures that IMED had taken in these circumstances before disclosing the information onto Annalise were sufficient to de-identify the personal information, and the APPs would not apply. But importantly, these measures were not just technical, but also contractual and organisational. And we've got in the handout some of the measures that were taken that you can refer to. But the sort of technical controls that were taken included segregating the patient data from the underlying data set, time shifting the dates to random dates that still made the information usable and valuable, but it took that data point away to assist with the identification. There were various hashing techniques that were used, and there was an aggregation method that was used to into large cohorts to avoid identification of outliers. From a contractual perspective, in handing the data over, there was obviously a contract between IMED and Annalise, and there were obligations in there that prohibited Annalise from doing any act or engaging in any practice that would result in the patient data becoming reasonably identifiable. So seeking to re-identify the information was clearly prohibited under the contract. They weren't permitted to disclose or publish the patient data for any purpose. They were required to store it in a secure environment, and also they had to notify IMED if they were inadvertently provided with any information that hadn't been properly de-identified, and that occurred on a few occasions. It came out in the inquiries, but Annalise reported that to IMED. The information was destroyed and the issue was resolved. Importantly, there were also governance measures that were put in place. The 5 SAFE principles, which a number of you may be familiar with, were adopted. The CSIRO process that's referenced in the OAIC's guidance was adopted as part of the de-identification, and various other steps. So ultimately, the Commissioner concluded that although the steps taken by IMED could not entirely remove the risk of re-identification, excuse me, the Commissioner was satisfied that it reduced the risk to a sufficiently low level and was supported by sound data governance practices. Therefore, the data that IMED had shared with Annalise was not personal information and not subject to the Privacy Act. Might leave it there, Jenny.
Thank you so much. Over to you, Mark.
Thank you.
I could hear about it all day.
Yeah.
Such a thing.
Yeah, I mean, it is a very interesting case. And as Francis says, I've kind of been given the task of commenting on what wasn't there, what wasn't in the report we might like to see. But before I do that, I think it is worth just, first of all, commending the OAIC in publishing this report in the first place, because they weren't required to do so, but they have chosen to do so. And I think it's a really useful contribution to the literature and helps us to understand their thinking and approach in relation to de-identification in circumstances like these. So I think it's a really good step and helps improve clarity. That said, I still, we always hope that things are going to be addressed that perhaps weren't. We always want people to go further than perhaps they have. And I would have liked to see more in the report in relation to the significance of context and the data environment in particular. As Francis says, data environment and context is so important to that question of identifiability, so important. And yet the very first reference to de-identification as a process describes it just as a two-step process, describes it as the first step being one where you remove identifiers like name and address, and the second step being where you remove the other information that might lead to an individual's identification because of its it's unusual or it's remarkable, or in circumstances the combination is rare or the combination is unique or unusual. There's no mention at that point in the first mention of de-identification as a two-step process of context, and yet context is really important in any case of de-identification, and particularly in circumstances where the same data can be accessed by more than one organisation. Because personal or data may be personal information in one context, may be personal information in the hands of one entity, and de-identified in another context, de-identified in the hands of another entity. And there's useful guidance here in relation to de-identification from the perspective of IMED, from the perspective of Annalise, but there isn't the same consideration given to whether or not, once the data has been through that process of de-identification, it is or is not personal information from the perspective of IMED, from the perspective of the organisation that is disclosing or sharing information. And I would have liked to have seen more on that. The status of the data post the identification from the perspective of IMED isn't really addressed. And I think that's significant, and I'm going to come back to that in a moment. But before we get to the de-identification, before the data's been de-identified, I don't think there's any question as to whether or not this is personal information in the hands of IMED. It's personal information which is subject to this process of de-identification. And the OAIC have been clear in previous guidance that de-identifying personal information is itself a use of personal information for a secondary purpose. So if the de-identification of personal information is itself a use of personal information, I would expect there to be something about that use notified to the individuals whose data is being so de-identified. And I did find it a little bit surprising that the report doesn't further consider what information might have been given or should have been given to patients about the identification process itself. But okay, so let's assume that the identification process that's applied has effectively de-identified the data in the hands of Annalise.ai or Harrison. What about from the perspective of IMED? What's the status of that information from the perspective of IMED? And I just want to draw attention to, and perhaps draw some parallels with, a recent European Court of Justice judgment.
There we go.
So, no?
Yep.
Okay. The European Court of Justice recently considered a case on quite different facts, but considering the obligations that one organisation might owe in relation to data that is provided to a third party, when it is agreed that the data in the hands of the third party is effectively de-identified or anonymised. This was a case involving survey data being shared with Deloitte, as it happens, and Deloitte was then engaged to provide some analysis on the data. There's no question that the data that was provided to Deloitte was identifiable to Deloitte. It wasn't, but the entity, the organisation that provided the data to Deloitte as a third party and asked Deloitte to undertake the analysis, themselves retained the means of re-identifying the data provided to Deloitte with the individuals. So from the perspective of the organisation that shared the information, the court found it remained personal information, or in the European context, personal data. And as it remained personal data from their perspective, when considering the obligations they owed as a data controller in relation to personal data, the fact it was de-identified or anonymous in the hands of the third party was neither here nor there. So I would have liked to have seen some consideration given to the obligations that IMED may or may not owe in relation to the data, in light of whether or not the data shared remained identifiable data from the perspective of IMED. And if it was, because IMED retained the original data, retained means by which they could re-identify or link this data through to individuals, if that was personal information from the perspective of IMED, then this engages the responsibilities under the Privacy Act in relation to the processing, handling, use, disclosure of the information, including in relation to questions around APP6 and whether or not this was directly related and a reasonable expectation as a secondary use of the information. And here, Maureen, I think this is the opportunity to connect with some of that patient and consumer engagement and answer that question whether or not this is a reasonable expectation. We get to ask that question if it is personal information from the perspective of IMED. We don't get to ask that question if it's not. So it begins to leverage some of the obligations under the Privacy Act from that perspective. And also other obligations, such as those in relation to APP10, which relate to data accuracy. And there is a responsibility on developers of AI models, according to the guidance under APP10, to take reasonable steps to ensure the data that's being used is of appropriate high quality, is up to date, is complete, and is relevant for the purpose for which it's being used or disclosed. Again, we get to ask those questions in relation to relevance, in relation to quality, if this is a secondary use of personal information from the perspective of IMED. But if we don't consider that question, we don't invite further consideration of IMED's responsibilities in that regard. So those are some of the areas in which I would like to have seen the report go further, and it does go down to that issue of context. Even if you accept that in the hands of the third party it wasn't identifiable, what does that mean, if anything, for whether or not it's identifiable to the IMED, to the party that's disclosing it? And what does that then mean for the obligations they own? The last thing I'll say before we go on to Kit's presentation and open up for questions, is because I realise we want time for conversation. Is the OAIC does also recommend that developers seek contractual assurances in relation to a number of things, in relation to any data set which is shared for training of AI, such as that the organisation which is providing it has the authority to provide it, asking for any copies of information that's provided to the individuals about to whom the data relates. We don't have any consideration here as to whether or not those particular terms were included within the data sharing agreement between Mohammed and Annalise.ai. So in summary, I go back to what I said at the outset. I do commend the OAIC in publishing this. I think it is a great step in the right direction. But to be honest, for me, it raises almost as many questions as it seeks to answer. And there are a number of areas in which I would like to have seen it go a lot further in relation to some specific issues, particularly that issue of context and viewing the same data from the perspective of different entities.
Thank you, Mark. But this is precisely why we're having this conversation, I think, because these are such important questions to all of us. And now, great delight, hand over to Kit.
When Jeannie asked me to join this panel, I said I was worried that I was little more than informed pundit in this area, because I really am representative of an end user in this space. I'm a digital health researcher myself. I work a lot with innovators who are trying to drive digital transformation with their own projects. And I'm also technical. I work hands-on in dev and AI, and I'm going to try and make 3 points that call to each of those. And in doing so, I will probably expose myself and the panel will give feedback, but I hope that will be illustrative. I think the first point I wanted to make was that one thing that really stood out to me as a little bit of a light bulb moment was the idea that the technical feasibility of de-identification is suddenly racing away from us. I think advances in AI itself, and particularly generative AI, will make it increasingly easier and possible to deal with increasing complexity when it comes to de-identification. And I guess that raised the possibility for me that have we been implicitly relying on APP6 to prevent surprising data uses of which this could be an example, because of the technical infeasibility to date of doing this de-identification? And has this been a sort of guardrail that's suddenly going to be eroded? I think that's sort of interesting to me. The second point I wanted to make was really in relation to this idea of innovators and what they're trying to do in the space. So I think for anyone working in research and development, we know that that's an inherently uncertain activity. Whether or not it's going to succeed is almost always hard to predict in advance, and particularly when it comes to AI. You may end up pushing it in directions, particularly in terms of the way you use the data you're bringing to bear, in ways you weren't expecting to do in the first place. And one thing I hear from people working in the startup space, and I'm not sure it's always true in the clinical space, I think there's actually quite a lot of maturity around these kind of issues, is that governance and compliance is really something that can be treated as a future problem, or at least something that is a qualified issue to navigate and manage, rather than something you wholeheartedly sign up to dealing with from the start. And so I think, pragmatism of the kind we see around what does re-identification look like, expressed in this guideline is guidance is very welcome. But I think consistency and clarity is incredibly important actually in this space. It's important because it goes directly to the costs of working in this space with people trying to innovate. It goes to the kind of support we can offer to people. How do you structure support mechanisms when the landscape is shifting all the time? And it also goes to investment. Investors are less likely to invest in areas where there is a sense that maybe the governance landscape is constantly shifting. And I think Australia historically has really lagged behind when it comes to digital innovation because of some of these issues. So I think anything that can drive forward consistency, and if this is an example of that, is great. The uncertainty I had, and this is my third point really, is does this really help with consistency? Because as Maureen alluded to, the APP is not the only thing in town when it comes to navigating governance in the health space. We have the NHMRC national standards, we have the DISR AI guardrails that talk about consent, albeit in a very narrow sense, particularly in relation to First Nations people's use of data. And my view, and I'm so happy, Mark, you made that point about this idea of context and de-identification being in use, because my read, I also sit in the ethics committee, is that they would absolutely view this as sort of a version of making a fait accompli. We've done the process for which we would need to ask permission, so now we don't need to ask permission. In terms of de-identifying the data so you can use it. And I think, Maureen, you also made the point about a moral risk here, which is, would we deplore the situation where the people who contributed their data to enable a model would be subject to lower protections than the people who are subsequently then put through that model as personally identifiable data because it's used for healthcare management? Would we accept that situation, that your generosity in contributing is subject to lower protections than the people who subsequently get to use it to improve their health? I don't know, but my point is I think all of those would be ethically relevant. And so what I'm getting to is I think we should deplore a situation, or any situation, where we end up with a two-tier situation where industry somehow is able to race away from what we can do in the public space. Not because I'm anti-industry, but because I think the university sector and the healthcare sector have so much to give in this space, and we actually want to make it easier for people to work together. Doing AI research is hard enough, I think, without us being in sort of parallel lands where people can't talk to each other. So I'll pause there.
Thank you, thank you. We're definitely not going to critique or instruct your response. It's incredibly useful for us. Now, before we turn over to the people who are in Zoom land and the people at the table, just thought we'd go through the panel and just ask them if they've got a comment that they would like to make, having heard everybody else's contributions, because of course we had a quick chat, but we didn't actually hear what people had to say.
I'd like to
Maureen.
pick up on the concept of context and around consistency. And I have to say, it depends. It depends.
You sure you're not a lawyer?
Because
That's
depends.
5,000,
It
please.
depends on the question being asked. It depends on how it's going to be used. There's too many factors to just have a cookie cutter approach. It is important to take those things into context. Interesting what you're saying about re-identification. So in the clinical research setting, it is allowable for that organisation that's going to perhaps de-identify the data to provide to a third party to retain the ability to re-identify the patients, because the research being conducted may have outputs that they need to contact those patients about that research output. Now, it's not the researchers doing the research that are allowed to contact without that process being properly documented and approved. But nevertheless, there is a case of where that would be applicable. But that's not every case. It does depend. So I think that were the key things that I took out of the other comments.
Thank you.
Look, I
Sorry,
think
Francis, I was
No.
looking at Mark.
that's Francis next. That's all right. I think Mark's comments about what wasn't said is very interesting, and because I indicated when I started my comments, the OAIC and the Commissioner were quite careful to point out that perhaps this was not everything, not the full story, and moving forwards as well. But we helpfully got this sort of snapshot and a bit of an analysis of the de-identification process and the Commissioner's view on that, without saying that necessarily these other things were or were not taken care of. And I think it's been reported that perhaps the processes that MedAI is using, or iMed rather, is using now are a little bit different than when they were when the inquiries were commenced, in terms of what they're saying to their patients up front about using the data to train AI and those sorts of things. So I think we take what we can from the decision, knowing that it was deliberately, or rather the report, knowing that it was deliberately scoped quite narrowly, and we keep having these sorts of conversations about those other issues which are very much on the table. I think particularly in this commercial context where the data was being used, patient data was being used without notice or consent for that quite obviously commercial purpose of training the AI model.
Thanks. Mark.
I think I'll respond to Kit's comment in relation to the need for clarity and consistency here, because I agree it's incredibly important, and I don't want to come across in any way just as suggesting that we want to be making things more difficult or more complicated or harder for organisations to do the right thing. And I think this report was issued by the OAIC in part because they want to support organisations to do the right thing. And so this clarity and consistency is really important. But clarity and consistency in and of itself isn't enough, obviously. No, it's cleaning the windows doesn't put your house in order. Just might make it obvious to others when it's not. So you actually need also to ensure that the activities which are being undertaken are the right ones. So clarity helps to enable the action that we want, as well as to prevent the activity that we don't. So if we have this enabling governance, which does support the use, we do need the clarity and consistency, but we also we need it in a way that gives people confidence that the data is being, because my experience in different contexts is also that there is general support for action that would improve care. People aren't anti-progress, but what they want to make sure is that they're not taken advantage of, their vulnerabilities aren't abused when they trust their data to others, and that data is used competently to deliver benefit. So if we can have the mechanisms which allow that to happen, that's what we should be clear and consistent about. And if so, we can enable the use we want, as well as give people confidence that the misuse is going to be, not that it will never happen, but individual will be held accountable if it does.
Can I respond with a question to that, which is, do you perceive any then governance gap in enforcing things like a requirement consent if it falls outside the APP now, as it seems to effectively do, right?
Well, I would question whether it does,
okay.
But even if it did, as you yourself said, it's not the only game in town.
Yeah,
So we've got common law duties of confidentiality, we've got the new statutory talk for misuse of private information, where deliberate or reckless, intentional, reckless, and serious. We've got and the ethical standard. I mean, there are other things as well which I think rightly retain the significance of consent within the landscape overall. But my own view here is we shouldn't be relying upon consent to ensure people do the right thing.
It's interesting to consider the prospect of the introduction of the overarching fair and reasonable test that may yet come in with a further tranche of privacy reform, and how this sort of scenario might be considered in this context from IMED's perspective. Is that a fair and reasonable use of personal information that was undertaken there?
Yeah, I think that's a fantastic point. And parallel to that, we've got the Productivity Commission report, which is suggesting that instead of going down the fair and reasonable route, we should have this outcomes-based regime where best interests of individuals are taken into account.
But with a safe harbour.
Oh.
Sorry, as somebody who works in financial services, safe harbors just mean it actually doesn't revert to outcomes-based regulation. It reverts to tick, have I complied with this list of 6 things?
Well,
but yes, an outcomes-based response.
That was a claim whether or not they worked out a way to actually deliver it.
Yes, indeed. But yes, there's other ways of dealing with the issue, albeit the uncertainty about the role. I think that is at the heart of it. What does de-authentication mean for this regime? Now, at this point, Abby, if you can turn, we're looking at a screen. So now we are going to, oh my goodness, there's already a question.
Yeah,
so
we've got a couple in
there will be time for questions in the room, but we're going to, if we could put our face, the people, can you, Abby Ward sitting over here, organise the event. Thank you, Abby. If you can turn the screen so we can see the Zoom people, that would be fantastic, or at least some of them. And then if you bring the questions up, you can bring the questions up on the side, I think, so that we can see them if you click. And the tech competent person in the room who's under 25 will help us at this point. You should just be able to move your cursor so you can see questions, at least on your screen.
Oh yeah, I can see them. Yeah. I just thought you wanted me to.
Oh, well, we could see them briefly on there.
Did
but
you?
Yeah, we did, but it's okay. There was a question. Do you want to, one of you want to mediate some questions, or shall I come around and do it?
No. Yes, we've got here. What did the Commission or the panel feel about one, transfer of this de-identified data to overseas for analysis and training? And number 2, was this data in this case study done in Australia? And then in brackets, they've just said, reason I ask is usually when we tend to transfer even de-identified clinical data, for example, to an international registry, ethics seems to be a big concern and have curtailed further research.
I didn't pick up from the report any mention of the data being transferred offshore. It's not to say that it wasn't, but it's not referenced in the report.
I agree. It doesn't seem to be addressed by the report, that issue. In relation to overseas transfer generally, I mean, it is not unlawful, but additional requirements attach to disclosure to overseas entities. And in general terms, they seek to ensure that the data, when it is overseas, is subject to similar protections that she would be subject to if it were kept within Australia. So you can share data overseas, but there are additional controls, requirements which need to be met before you do so.
I think there's a higher awareness in those considering, you know, research activity. So I'm talking here about ethics committees, for example, in the transfer of data because of the uptake of cloud and the use of cloud. So data sovereignty has become much more of a topic that's considered at a higher level in these conversations, whereas it was exactly the same before, just wasn't really thought about so much. So I think it's just brought that to the fore, and that's why these questions now get asked. What we've learned over 20 years of working with ethics and governance officers around the country is that, to Kit's point,